All right, last but not least, Bethany Dwyer was appointed to serve as an assistant county attorney in January of 2015. She started in the litigation group, and a couple years ago she came over to our environmental group, and her practice primarily focuses on environmental enforcement.
Hello. Thank you for sticking with us here till the end. Several of the topics I was going to kind of cover and touch on have been addressed from our speakers this afternoon, so I'll try and kind of keep it moving and go over those a little faster so you don't have to hear the same information twice. But in our group here at Harris County, we do quite a bit of enforcement. It's a small group. We only have 5 attorneys, 2 support staff, and we cover a lot of the things you've heard from pollution control today. You heard with Professor Irvine and the flooding and all those kinds of things. ARGMA, ITC, we handle all of that kind of stuff with a very small pool of people. We do enforcement on air, water, and waste statutes, and also another big one would be our floodplain management. Our main clients, we have a pretty wide range of clients. Harris County is our client, but that ends up falling into a bunch of different groups and entities. You see we've got Commissioners Court, Pollution Control, who you heard from Dr. Babin today, the Engineering Department, Toll Road Authority, Public Health, each of the different commissioner precincts, and even just handling questions and concerns that come from the general public. They're not really our client at that point, but having to interact with them, answer their questions, kind of be even a liaison sometime with these entities. I am going to primarily talk about enforcement. We do regulatory work though as well. You heard about the Superfund sites, the San Jacinto waste pits, something our office has been very involved in, commenting on TCEQ permits, like ITC's permits, Exxon, Valero, all of those that you've heard about today. We also have our own operations, our own sites that we have to make sure are in compliance with all of these rules. We don't want to do enforcement on ourselves. That would never look good. So we do have to make sure we're not violators, that we're operating within the realms of these rules. Here's really all of our statutes and regulations that we work within. You've got the Water Code, Chapter 7 actually gives us our enforcement ability. Chapter 26, you're going to have water quality controls. That's going to be your groundwater, your waste, your sewage. Texas Health and Safety Code, you've got solid waste, air, you've heard of all these things today. Locally, we do stormwater quality and floodplain management. Floodplain management has been huge post-Harvey, as you can imagine. So our practice that already dealt with a lot of traditional environmental enforcement has really blossomed and bloomed with the recent flooding. Our 2 main clients are pollution control and engineering. We have authority to enforce against these companies and corporations that have these unauthorized discharges that you heard about earlier. The unauthorized waste disposal, they're just dropping, it's not really the illegal dumping, but they are just allowing their waste to be in places that it's not authorized. That can have then multiple, trickle-down effects. The refineries can have their air issues. We've seen a lot of that this year with ITC, Chemco, Exxon. Harris County Engineering, those we get, like I said, with the floodplain regulations, really forcing people to come up to current standards, making sure that they are developing to avoid flooding impacts and the environmental issues that you saw this morning in our first presentation, where people are ripping out their homes, and all of that has to go somewhere, hoping to prevent that environmental impact. On-site sewage facilities, we work with the TCEQ on that one. Actually, all of our pollution control cases, as well as our on-site sewage facility cases, we do work with the TCEQ on those. They are a necessary and indispensable party, so when we file those lawsuits, The AG's office joins in with us, and it's a joint case versus our floodplain regulations, construction for stormwater, and stormwater quality permits. Those are just going to be Harris County suing. Here's a look at what our caseload has looked like recently. You see we have a pretty high amount of air cases. As Dr. Babin suggested earlier, air is a big concern because we have to continuously breathe it. If you had looked at this same kind of data we pulled for this chart 2 to 3 years ago, it would have been more heavily skewed to water and waste. But with some priority shifting, we are seeing more air, and I think we will continue to see more air cases. We currently have about 20 to 25 cases that kind of fall under this type of traditional environmental enforcement. That number, I think, is going to grow and continue to grow, especially as pollution control ups their enforcement, they get more personnel. We're going to keep seeing the effects of that. In addition to the 20 or so cases we have that fall in this range, we have about 190 floodplain cases. About 120 of those are directly related to Harvey and the flood damage that those structures received during Harvey. This multimedia number you also see is maybe a little low or misleading because cases can come in as air, stormwater quality, waste, any of those. But really the more you dig into the cases, the more you look into the background, they end up touching on all of the topics. I've got a couple of cases now that came in as air emissions cases, but then you start looking through it and they've got stormwater quality issues, they've got waste issues where they have open dumpsters where trash is on the ground, they've got maybe septic systems that are spewing. So you think you have a one issue case, but more and more we're really seeing 5, 6, 7 issues per case. We're also seeing more cases, traditional pollution cases with waste, like a salvage yard, where they've got oil spilling onto the ground, or they've got oil drums that shouldn't be there. And they also don't comply with our county regulations. They're also in violation of the floodplain regulations I mentioned because they have unpermitted development, or they're violating the salvage yard regulations because they don't have a salvage yard license. So not only are we seeing a mix within traditional pollution cases, we're now seeing a mix between pollution control cases and local county regulation cases. They're getting more complex. Dr. Babin's talked a little bit about the AIR program and the kind of issues that come up there. We do see a lot of emissions events, especially more recently. Most of these companies do have permits that allow a certain level of emissions, but they're often exceeding them or not properly reporting the events and going out of their permit limits. And that's something we really rely on pollution control to investigate, and they do a great job of getting us that information so that we can move forward on our cases and say, hey, Exxon, ITC, I'm picking on them, but those have been our recent ones. You weren't permitted to have a giant air emission event where your tank's caught on fire and you have all this burning and smoke and particles going out into the air. Generally, how it works is they do have to report these air emission events within 24 hours, give us an initial report. They do have 2 weeks to follow that up and give a more detailed report. And we get a lot of our information from there kind of in conjunction with pollution controls investigation. It allows us to kind of match things up, see where there were potential deficiencies. Did the company know something that they didn't turn over or didn't report? It can make a case well interesting to see if there's a difference between a pollution control investigation and maybe something in their report. Under the AIR program, it just says no person shall discharge from any source whatsoever one or more air contaminants or a combination thereof in such a concentration and of such duration as are or may tend to be injurious to or adversely affect human health or welfare, animal life, vegetation, or property, or as to interfere with the normal use and enjoyment of animal life, vegetation, or property. That's really broad, but it kind of needs to be, because a lot of things can impact our air. A lot of things can end up in our air, and they really can affect our everyday life. When you're breathing these things in over and over again, you end up with headaches, you end up very nauseous, you end up not being able to leave your home for fear of breathing in whatever these things are. So we really do want to prevent businesses and industry from interfering with the people who live around them or work around them being able to enjoy their lives. We have the water program, the stormwater program. It makes sense. You can't discharge sewage or waste into any of the waters of the state. We don't want people's sewage or chemicals in water that we could come in contact with. It can create not just the problem of having dirty water, but again, if people are coming in contact with this water, what are they getting on them? What are they getting in them? If this stuff's in our water and we have a flooding event, where is that water going? The ripple effects of things ending up in our water is a real concern, and it can come from something as small as things outside the dumpsters, the trash bins, receptacles. All of that can run off and get into our water supply, our water system. And you see it ends up in our rivers, streams, lakes, waters. Things you wouldn't think are connected at all are suddenly connected through runoff, and in a site that could be far from a neighborhood park because of the runoff effect, because of the dumping in water, kind of however you get there. It's now in the park where your dog is running into the lake to catch the ball. They're now covered in this questionable water and are now coming back into your home and bringing in those sediments and particles into your home. Again, the ripple effect can be much wider than you would initially think. The waste program, this tends to deal with your solid waste and how you dispose of your solid waste. Again, we don't want people just going out and discarding their trash wherever they want, especially not in terms of chemicals or oil drums. These really just any kind of trash that you can think of. If you wouldn't want it in your home, we don't want you just dumping it somewhere random where you could see runoff effects again. Water gets into these types of sites, ends up in our roads, ditches, ponds, everywhere. Again, we have a very broad definition we can work with. It allows us to capture pretty much any kind of waste you can think of. We do, you heard from Ann in the last presentation, we do have to give some kind of notice that people could be breaking the law. Ours, we get a little bit more wiggle room. We get to be a little broader because we aren't throwing people in jail unless we get to a contempt stage. We are fining them. So ours doesn't have to be quite as detailed as the criminal side, but it's still pretty detailed in putting people on notice that any of these things could be connected to the kind of waste you're dumping. See some examples of the kind of waste we see often. These are these oil drums or chemical drums where people are storing things improperly. Under our codes, they have to have lids, they have to be properly contained, they do have to be disposed of properly. You can't keep a certain number of these on site. And you can see the problem of when they're not maintained properly, the leaking, the on the ground, the rusting through, and how that creates more problems down the road. So that was a kind of a quick overview of our traditional pollution control cases. You often see these all mixed in together. You could have your solid waste with your air emissions, with the stormwater quality, all in a case that happens really more and more frequently now. And you start seeing more and more runoff, or more and more repeat violators, where if we've tagged them once for this or tagged them for an air emissions event, you go back again and they have the same violation, and maybe even a new violation they've compounded on their oil drum and have made it a worse situation. The other big environmental impact, which you heard about this morning, that we enforce and deal on, is the floodplain cases. The regulations were first enacted in 1973. It deals with building in Harris County. To make any man-made change in the unincorporated area of Harris County, you have to have a permit. And that permit is supposed to make sure you comply with certain floodproofing requirements to prevent repeated flooding of structures, and making sure that all of Harris County actually then can get their FEMA-backed flood insurance. After Harvey, we can see where that's a big concern, to make sure everyone continues to have their FEMA-backed flood insurance. So we have to take all necessary and reasonable steps to make sure that all the structures in Harris County are compliant with our floodplain regulations. Kind of the catch-all that we operate under is construction of new structures and substantial improvements, and existing structures within the area have to have a permit before they begin even building. And you might think, okay, that might mean before they pour the first piece of the first bucket of concrete. It actually goes further back than that. You can't even move dirt onto the property without getting a permit. By moving dirt on, you're changing elevation. It could force drainage to your neighboring properties and flooding them. And so even to bring that first shovel full of dirt onto your property, you have to have a permit. Hurricane Harvey. We all remember Hurricane Harvey. In the unincorporated area of Harris County, of course, there was significant flooding. A lot of homes were hit with what we call substantial damage. That means more than 50% of the value. That means that the damage done to the property is more than 50% of the value of the property. So if you have a $10,000 home and you got 2 feet of water in your home, you were probably substantially damaged, because it's probably going to cost more than $5,000 to fix that 2 feet of damage. If that's the case, your home has been substantially damaged, and before you can rebuild or repair, you have to get a new permit. And you have to come up to current standards. After Hurricane Harvey, we did pass new regulations that required homes to be built higher, not just homes, but structures to be built higher. And that we're really seeing the effects then of how a flooding event can have environmental impacts, and why it's so necessary to enforce those regulations and to keep increasing those regulations and those requirements. Because here comes Imelda 2 years later, and you're hoping that homes that were substantially damaged in Harvey have now come up to new standards and have avoided flooding that requires them to rip everything out again. It's in the curb, it's in our landfills, it's maybe in our waters that are moving around from house to house. It all becomes a very big environmental problem if we're going to allow these same homes to keep flooding over and over again. So that's where the substantial damage is incredibly important after Hurricane Harvey, and is really used as a way to prevent repeated environmental concerns, and honestly a drain on FEMA and our insurance. Of those 190 cases that are floodplain related cases, about 125 of them are Harvey damaged homes, in this case, Harvey homes that were damaged, and we're really trying to make sure come up to current standards to prevent those future issues. The other big issue from Hurricane Harvey, from a flooding standpoint, was Arkema. We've talked about Arkema a lot today, but Arkema was very unique in that, well, actually it wasn't unique, sadly, but a unique feature of it was not just its environmental impact in terms of the fires, but that they didn't actually have most of their permits to have those structures and facilities there. And if they did, if they had, they would have had to fall under this critical facility definition that would require them to take additional steps, not just to meet, basic commercial requirements, but to really take steps to make sure they didn't flood and didn't have a negative impact in a situation like Harvey. We saw the water rise in the videos that the CSB did. The fact that the flooding shut down their electrical power systems and created this situation where the peroxides became hot, they became flammable, we had our burning, all of that. There's, I think, a good argument that if they had gotten their permits, had been required to meet those flooding standards, it may not have been as bad as it was. It might have been avoided. It's at least a good argument as to why the floodplain regulations are important, because as we see more and more flooding events, these critical facilities like Arkema, even ITC, Chemco, Exxon, all of them really need to make sure that they are meeting the requirements of these critical facilities so that a flooding event doesn't trigger an even bigger environmental event where you've got air emissions, outdoor burning, you've got, some kind of substance in the water. So this critical facilities is a really important tool to address environmental concerns with flooding. In terms of enforcing our floodplain regulations, if it appears somebody is going to violate this part of the statute, we can go ahead and seek injunctive relief to keep a person from building, from continuing to build. We can stop them from using the facility until they meet current standards. It also allows us to seek civil penalties. And going back to kind of where our enforcement authority is, we get our enforcement under Chapter 7 to allow us to do this. A civil penalty, we get to seek up to $100 a day for each violation for each day. So if you've got a property that has 3 or 4 structures that aren't permitted and haven't been permitted since the 80s, you're looking at pretty high penalties, and sometimes those penalties can be significantly higher than even the penalties we could get under the traditional pollution control statutes, the emissions that cap at $25,000 per event. Because often you're only getting 1 day, maybe 2 events from an air emission event or something like that. But if you can go back 30, 40 years on a floodplain violation at $100 a day per structure, those violations can really impact kind of cost of doing business when our traditional pollution control ones may not. We've kind of talked about this a little bit from other speakers today. Our cases generally come from the emergency incidents, ITC, Chemco, Arkema. They come from routine inspections, the complaints that pollution control goes and investigates. They, come away with their violation notices after trying to work with property owners. They can't get compliance, they'll refer them over to us or the district attorney's office. That's kind of your normal process. Our cases really come from pollution control and engineering after their inspections, and we rely on their information to go forward. If it's one of those traditional pollution control cases, so pretty much everything except for the floodplain and stormwater quality under like a new construction situation, we have to seek permission from the TCEQ to take penalties on the case. We have to seek authorization from Commissioner's Court first and foremost. The statute does require us to have local authority to file a lawsuit. We do have to make the TCEQ a necessary indispensable party to our lawsuit, so we are forced to work with the AG's office on these cases. And then I'll get into it a little bit later, but under the legislature's current and looks like ongoing attempt to curtail some of our enforcement, we do have to give notice before we seek civil penalties. The relief we look for is fairly traditional. You've got your injunction relief. We want to stop a violation. We can get temporary restraining orders in extreme cases. Temporary injunctions we can get that will last until trial. We have our permanent injunctions, default, and trial on the merits. These are all, we use all of these in cases. We use variations of all of these in cases. It just kind of depends on the case and the violator where we fall into that kind of injunctive relief. Civil penalties is another big one. As you can see, that we can only get up to $25,000 a day for each of the violations under the traditional pollution control type enforcement. And then $1,000 for stormwater and $100 for floodplain. The injunctive relief can actually be a really good tool when our civil penalties aren't going to be very high, because it does allow us to sometimes ask for things that may not be traditional. We can maybe ask for logs showing employee training on better management practices. We can ask for the companies to do checks on systems or checks on the facility itself, like the pipings, the fittings, all those kinds of things. Things that might be kind of hard to get from a jury. We can maybe sometimes get in our injunctive language just in front of a judge, or even working with the violators to get something that can really hopefully prevent a repeat of the event we're suing on or enforcing. I mentioned a second ago the legislature and kind of how that's impacting our enforcement. It's created some roadblocks. It's created some challenges for us. It started in 2015, really. I think that was right around after Volkswagen, and Harris County being one of the only counties that is able to pursue the Volkswagen litigation really without. Yes, there's only two of us. And that the legislature was not very happy about it. And we're seeing the effects of that, and we're continuing to see the effects of that. The first is that we're capped on what we can recover. We can only recover up to $4.3 million. We have to split that with the state, so we'd only get 2.15 if my math is correct. And then the state gets the rest. So if you've got an $8 million judgment, we get half of 4.3. The state gets the other half of 4.3 and the remainder. That was one of the biggest kind of handicaps in terms of our enforcement ability in civil penalties. In 2017, it got a little worse. That's when we now have to send the Office of the Attorney General and the TCEQ notice of alleged violations, the relief we want, the facts behind those violations, and they get 90 days to review that, and they can say, okay, go ahead, we're not going to take any action. County, you can go ahead and sue on this. We'll just join as a party. Or they can go, we'd really like all the civil penalties. We're going to take this case. You can't sue on it. Or they can also do their own administrative proceedings and knock us out that way. So we've got a kind of a big handicap in terms of being able to file quickly if we want civil penalties. We're waiting 90 days from when we send the letter before we can file for civil penalties. We can still file for injunction if we need to, if we need a TRO, if there's an immediate health issue, like sewage, raw sewage spewing somewhere. That would be a good reason to not wait 90 days to file a lawsuit. we'd have to later amend to get penalties, but there's nothing stopping us at this point from the injunctive relief. That could change, though. This year, we were able to get away from this session pretty much unscathed, or additionally unscathed, but there were some concerning bills that were up. Probably the most concerning was that the TCEQ would be able to come in and settle any of our cases without any say from us. They'd get complete control no matter where we were in the case. They could come in and go, okay, we're going to settle, regardless of what the local government wants to do. And that would really tie our hands in terms of our enforcement. They also were trying to prohibit all contingency fee contracts from environmental enforcement. And really, again, that ties our hands in who can file these lawsuits, what resources we can use to file these lawsuits, and to enforce environmental infractions in our own areas. That's really forced us, this constantly changing legislature has really forced us to get more creative in how we deal with our enforcement and how we get compliance from violators. It's funny enough the floodplain violations can really come in handy. Floodplain, we don't have to give the state notice. They're not a necessary party as of now. And so we can use that to get around some of the other enforcement handicaps that we're seeing in the legislature. Again, the injunctive language, that's something we have gotten more creative with. That's where we're requiring maybe employee training, requiring different maintenance logs, things like that, because we're not going to get the fees maybe or the penalties, but we will then be able to use that injunctive language to make sure that another air emission event doesn't happen, or a company doesn't keep releasing oil into a ditch, things like that. So we definitely do have a concern with the legislature. It's in part because we've got a couple of counties, ours included, that have been very aggressive in terms of our enforcement, and that's a good thing. We want to be aggressive with our enforcement, but with it might come some new challenges that we're going to have to get more creative with. And our office has been really good about being creative to get around and make sure that we can continue to have a robust environmental enforcement program here in Harris County. So that's everything I've got. Does anyone have any questions?
Charles Irvine earlier, who mentioned that during times of natural disaster, that the state suspends all of these laws, and so you can't file suit on like Magellan, for instance, that emitted millions of pounds during Harvey. So, but is it possible to like use those emissions events as precedent for their next, to say that they are repeat offenders, or is all of that information like stricken from any future lawsuits?
I've really not had that issue come up, and I have not dealt with that issue. Theoretically, they're not in violation if it's been suspended.
Right.
I think you'd have to be able to come up with a very creative argument as to, maybe that they weren't releasing just because they had floodwaters that busted a pipe or something. But instead arguing like, hey, they just completely disregarded, they took advantage and...
Well, my understanding is that many of these companies took advantage,
right?
And so how do we actually pin them for it if there's no laws in place during these times, and is it possible?
It's not something I've come across, and I would have to research and see. But I will tell you, luckily or unluckily, a lot of these companies have a long history of violations anyways. So we have other ones we can use to show repeat offender, and a lot of them since Harvey have continued to have violations. So we're able to use those as well. Sarah, have you come across that issue?
Yeah, we've looked at it, Arkham is a good example of one where some of them are related. And so what we've done is say that this is perceived under the statute because that didn't get waived. And I realize there's some legal arguments there. And there's also, when you look at the request with where it says the waiver, it says that they're waived. Remember the language about how, like one of the things that they waived is like the notice requirements for the air emissions, right? But the language kind of implies that it's only waived so long as you couldn't comply because you were dealing with the event. So arguably, eventually they are going to report it. It's just sometimes the time people get find out, it's like way past the point, right? So we're trying to get creative with how we proceed against those. And I think TCQ has even filed, like they filed against Valero now for the big event that happened, during Harvey. So there is some enforcement kind of using some of these principles. I think we just have to jump through more hoops.
Haven't waived the Clean Air Act measures though, so.
Is that, I think like in Arkema, we went under the water code itself.
Okay.
Because that wasn't waived. It was just enforced, so we thought this law and the statutes. Of course, we're not done with that.
Yeah. Any other questions? All right. Well, again, thank you for staying with us till the end, and have a good night.
Thank you, everybody.